You may be seated.
All right, good evening, ladies and gentlemen. Again, I understand that we now have a verdict, apparently, as to all counts. Before I bring the jury out, let me say this. I know that you have all anxiously awaited this day. This case has been pending for approximately 15 months, and it obviously has affected many lives, and that this is a very, very emotional time. I understand that. To this point, you've all conducted yourselves as I have requested, and you've done so gracefully here in the courtroom. I would ask you to continue to abide by my rules of decorum and ask you to please refrain from any emotional outbursts once you hear the verdict read. If you feel as though you might not be able to contain yourself, I would appreciate it if you would excuse yourself. This case is not about winning or losing. Remember also, as I mentioned a few minutes ago before we broke last, we must respect the jury's verdict. This group, as I said, has worked extremely hard. I've never seen a case where deliberations have gone on for this length of time and with this type of dedication by these folks. As I mentioned, they've put their lives on hold. They've worked very, very hard and diligently. They didn't ask for this assignment. They were summoned to jury duty, but they embraced their civic duty, and they're to be commended for it, and they're to be respected for it. So I ask you to just please keep that in mind, and please keep any comments or emotional outbursts to yourself when the verdicts are read. Thank you. All right, with that said, let's bring the jurors on out.
Jurors entering the courtroom.
All right, ladies and gentlemen, welcome back. I understand you have now reached verdicts on all counts? No. All right. Yes, ma'am.
We have deadlock on one.
All right. Let me ask you to step into the jury room for just 1 second so I can speak to the lawyers, and I'll have you brought back out in just a minute, all right? Ms. Corey, or Mr. Guy, or Ms. Wolfson.
Judge, we believe that you should, I think they've already indicated on which count they are deadlocked. And I believe at this point now, the foreman has announced that you have to look at that verdict form, inspect it yourself, make sure they have not checked anything. And I'm going to declare that one count mistrial, and then proceed to the other verdicts that they've arrived at.
All right. Mr. Strolla.
Judge, we would agree. I think at this point, they previously said that they had 4 counts and not the one, and they're still deadlocked. Normally, we would do a multiple Allen charge, but in this case, with the amount of hours, extraordinary hours they put in, I don't think another Allen charge would be necessary, Judge, or even fruitful.
Quite frankly, not even, I don't believe it's allowed by law.
We agree with your own.
All right, Mr. Dunn, you understand the situation and understand that apparently one count would be
Yes, Your Honor.
declared a mistrial. All right. Okay, then bring the jurors back in.
Jurors entering the courtroom.
All right, sorry about that, ladies and gentlemen. You can have a seat. I see juror number 7. You appear to be the foreperson. If you'll just hand the verdict forms to the bailiff, please. All right, we have verdicts in counts 2, 3, 4, and 5. I have the verdict form in count 1. There are no markings on it, but I will provide it to the clerk for the record. And based on the jury's inability to reach a verdict as to count 1, I will declare that mistried, and we will talk about how we will proceed with regard to that in a moment. The other verdict forms are in order. I'll give them to the clerk for publishing.
In the Circuit Court of the 4th Judicial Circuit in and for Duval County, Florida, in case number 16-2012 CF 011572 AXXXMA, Division CRD, the State of Florida versus Michael David Dunn. Verdict is to count 2. We, the jury, find the defendant guilty of attempted second-degree murder, a lesser included offense. We find that the defendant discharged a firearm during the commission of the offense. Verdict is to count 3. We, the jury, find the defendant guilty of attempted second-degree murder, a lesser included offense. We find that the defendant discharged a firearm during the commission of the offense. Verdict is to count 4. We, the jury, find the defendant guilty of attempted second-degree murder, a lesser included offense. We find that the defendant discharged a firearm during the commission of the offense. Verdict is to count 5. We, the jury, find the defendant guilty of shooting or throwing deadly missiles as charged in the indictment. So say we all, done at Jacksonville, Duval County, Florida. Juror number 7, foreperson, dated February 15th, 2014.
Does anybody need the jury polled?
Yes, Your Honor.
Juror number 1, are these your true and correct verdicts? Yes. Juror number 2, are these your true and correct verdicts? Juror number 3, are these your true and correct verdicts?
Yes.
Juror number 4, are these your true and correct verdicts?
Yes.
Juror number 5, are these your true and correct verdicts?
Yes.
Juror number 6, are these your true and correct verdicts?
Yes.
Juror number 7, are these your true and correct verdicts? Juror number 8, are these your true and correct verdicts? Juror number 9, are these your true and correct verdicts? Juror number 10, are these your true and correct verdicts? Juror number 11, are these your true and correct verdicts?
Yes.
Juror number 12, are these your true and correct verdicts? Thank you.
All right, ladies and gentlemen, the jury, I've said it several times, but I need to say it again. I want to thank you for your hard work, your time, your attention, and your dedication throughout these last almost 2 weeks. There will never be words that I could ever express to you to tell you how grateful I am, and that we all are, for your service, your consideration and dedication to this process. It's been a long 13 days, I believe now, and when you came on Monday, you recognized that obviously you were here for jury service and you had a civic duty to perform, and you have embraced that, and I truly appreciate it. I've watched you throughout these last 2 weeks, and I know how hard it has been for you and how difficult it has been for you, but you have performed your duties with the absolute utmost of professionalism. You are why this justice system is the greatest in the world. So from all of us, let me again extend my gratitude and thanks. Before I release you, I do want to advise you of some distinct privileges you have as jurors. And I alluded to this, I believe, back Monday or Tuesday of last week. And this is the last jury instruction that I will read to you. No juror can ever be required to talk about the decisions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether or not to preserve your privacy as a juror. You should know that your decision whether to talk about your experience is entirely yours. It's an individual decision. You do not have to vote on this as a group. Please remember, though, that my order regarding the confidentiality, your identity, remains in effect. That order will remain in effect until further order of the court. So I want you to keep that in mind. If you were to decide that you wanted to speak to someone about this case, whether it was family, friends, or the media, I would ask you to please not identify any of your fellow jurors. Because of the publicity that has surrounded this case, I have also been asked to advise you that if you wish to speak to the media today, we can arrange for a court administrator to escort you to the adjacent courtroom, which is courtroom 407, for you to be interviewed if that were your desire. Basically, we will take you through a back hallway and into this adjacent courtroom where you could be interviewed either on camera or off camera. You could be interviewed either with your voice recorded or not. That would be your choice if you decide to do that. You don't have to. You can just decide that you want to collect your belongings, and we will transport you back to the hotel to collect the remainder of your belongings and allow you to then go home. Keep in mind that if you decide to speak to the media either tonight or at any time, then the confidentiality of your identity obviously would not any longer be in effect. So I tell you that, and then you can tell the bailiff when you are excused from the courtroom as to your decision regarding an interview today. And if that's your choice, fine, we'll arrange for it. If not, then we'll have transportation for you back to the hotel. Again, ladies and gentlemen, let me thank you for your willingness to be a part of our justice system and for your dedicated service in this case. At this time, you are released, and I wish you a safe trip home and Godspeed. All right, Mr. Dunn, you're having been convicted of counts 2, 3, and 4 by a jury. You are remanded to the custody of the sheriff, as you already have been, pending sentencing in the case. I assume he's entitled to a pre-sentence investigation report.
Yes, Your Honor.
All right, so we will order a pre-sentence investigation report. For those of you that do not know, that takes generally about a month to prepare. My intention is to set this case for sentencing and additional consideration on March the 24th, unless somebody tells me they've got an objection. It would be set on that Monday to pick a day later in the week for actual sentencing. Other than that, I'm not sure what else there is to do this evening.
Judge, I might have misheard you. counts 2, 3, 4, and 5, correct? That's
I
what you have
hope I
there.
said that, but it is, counts 2, 3, 4, and 5, yes, ma'am. So the sentencing would be during the course of that week.
Yes, sir.
And then I would assume at that point in time, or shortly thereafter, we'll have some indication from the state as to how you want to proceed with regard to count 1?
Yes, sir.
Okay. Anything else from the state?
And testimony.
Yes, ma'am. While they're doing that, Mr. Strolla, anything that you can think of?
Judge, in terms of just the March 24th, if that can be tentative, obviously, I need to look at my calendar and possibly call your honor.
Sure.
Call the city, try to work that, Judge.
All right, that's, no, I understand. You may have other obligations, having been here for 2 weeks, so that's when I'd like to do it. If that presents a distinct difficulty or problem for you, just let me know, hopefully next week, so that we can then change the date to something that everybody can live with. It would be convenient for everyone. I also, while we're at it, was informed that there was an objection filed to Magistrate Sampson's report and recommendation regarding the jail phone calls. I believe that then is going to require a hearing. I don't know to what extent, Mr. Stroller, you want to be a part of that, but if you do, I will allow you to appear by phone. Ms. Corey, obviously, you'll be here. I will get in touch with, or perhaps you could get in touch with the interveners to see if they actually want to have a hearing or how they want to proceed.
We look forward to a hearing. We file a response as well.
Yes, ma'am, I
We'll
understand.
make sure that Mr. Stroll is copied with those.
Okay. All right. So the next court date, at least at this point, will be March 24. That'll be at 9 a.m. Actually, I believe we will vacate this courtroom and we will go back to courtroom 305 for that. Although that might be subject to change, I'll have to check with the chief judge about continue doing the sentencing in here versus in the other courtroom, which is a bit smaller, but I'll check with him about that.
Yes, sir.
Anything else?
No, sir. Thank you, Judge.
Thank you, folks. Thank you all. Have a great evening.
And everyone else, please exit.